message that's saying that cannot connect the use case as well as event or format is not been selected.
Hi, good morning. Wow, that's a little bit louder than I thought it was. Am our last hearing these eardrums out? Good down a little bit? Okay. Hi, my name is Andrea. I'm a reference librarian and assistant professor at Ohio University.
I'm Ellen Richardson. I'm a legal information librarian at Boston University.
And welcome to Preparing Future Lawyers to Find Their Inner Veronica Mars, teaching students how to use Facebook, Twitter, and other social media for investigative purposes in legal practice. Which is kind of a mouthful, but we really love the Veronica Mars part, and we couldn't bring ourselves to cut that out. And then the rest of it actually tells you what the session's about. So we had to leave that there. We're going to start off by talking a little bit about the actual practical applications of social media like Facebook, Craigslist, eBay, and other sites that attorneys are actually using hands-on right now. We'll talk about the ethical and practical matters that attorneys need to be mindful of, and that you, when you're teaching those to your students, need to be emphasizing them. And then we're going to talk about how to bring this into the classroom in a way that will be engaging and also useful to students.
So if you haven't already found them, on our program page on the Kelly site, we've got a couple handouts for you. We developed a bibliography. We were keeping our presentation a little bit on the lighter side, but if you wanted more background, some in-depth reading, check out our bibliography. And then a couple of the teaching skills that we'll go over. We also have handouts for those online.
Okay, so we thought about starting off by trying to convince you how important social media is, but then we realized that if you have read the news at all recently, you would be aware that this is a thing that's happening more and more frequently in pretty well publicized cases. People are bringing in social media evidence both at the police investigation level and in the legal practice level. Let's see, there we go. Lots and lots of examples of it.
And it's not just happening in the news. We always like to bring in case law just to demonstrate that we're not making this up. Courts are actually using it. So a couple of the major cases that you'll come across if you start doing more background reading, just to show you how courts are using social media. In Griffin versus State in Maryland in 2011, the court held that authentication of electronic communications, in this particular instance MySpace messages, based on the content and the circumstances of those communications, was acceptable in terms of authenticating this type of information in court. In Tienda v. State was a Texas case from 2012. The defendant was actually convicted of murder in part due to content he had posted on his MySpace page that was brought into court. In Dexter versus Dexter, which was a 2007 case in Ohio, it was a custody case. The defendant, the mother, was posting on MySpace about illicit drug use. She swore in court that she wasn't doing this, but posted on her MySpace page differently, and those were brought in, and it was a significant factor in the custody battle. And then finally, lest you think everything is happening on MySpace, because occasionally that's the impression I get. In Lalonde v. Lalonde in 2011, this is the Be Careful Who You're Friends With case. Another custody case, and there were photos on Facebook of the mother drinking rather a lot. And even though she hadn't posted them or given permission for her friend to tag her in them, they were on Facebook, she was tagged, and the court did admit them into evidence because they properly reflected the activity that was actually happening. So, just be careful.
As we all know, the vast majority of cases never make it to the trial level. So case law isn't really reflecting how frequently this is actually happening. And because of that, we have some stories that we're going to bring in from the practitioner perspective. Those go to our first point, which is that when you're teaching this in the classroom to students, you need to demonstrate relevance. You need to show them exactly how it's going to apply to their lives and their practice. Apparently I used this transition more than I thought I did. You're going to provide strategies for how they can actually investigate on social media. And you're going to frame issues in both practical and ethical terms. Demonstrating relevance. Ways that attorneys are going to be using this in practice. They can research potential jurors during voir dire. This is becoming more and more common as courts are providing internet access in the courtroom. You may have a team of attorneys, one of them doing the normal questioning, another one is in the background, looking people up on Facebook and determining based on their likes and their comments whether or not they're prejudiced to the issues in the case. I just had lunch yesterday with a bankruptcy attorney who told me that he regularly looks at Facebook to see if there are photos of people posing with assets they've claimed they don't have anymore, like motorcycles and boats. In personal injury cases, attorneys may log on to see if someone has just posted a status saying that they went base jumping, for example, they're supposed to have whiplash. In divorce or custody cases, you'll have evidence of relationship or questionable activities, and I have a pretty appalling example of that later on. Documentation of criminal activities, as Ellen just mentioned, there are actual cases where people will kill someone and then go on MySpace to brag about it. And then metadata is becoming more and more common. People are tagged or checked in at locations, and it's not what they say, but where they said it that becomes important in the case. Okay, so this is where it gets to the stories, and these are fun. So you have this man whose name is Joe, and he's making fun of this little girl whose big brother is Bill, and he's a 17, 18-year-old kid. Bill goes outside and punches Joe in the face, and Joe falls off his bike. Joe presses charges, a public defender is assigned to Bill, and she goes onto this board called Topics. If you live near or practice in, teach near a small town, the Topics board is a good thing to check out. It's kind of the digital equivalent of those old party lines people used to have. People just go on the Topics board in small towns and they gossip. So the public defender is looking at the Topics board, and she finds that Joe has actually posted on the Topics board saying, "I was not hurt. However, I used to date Bill's mother. She broke up with me because Bill doesn't like me. I'm hoping if I can get consent to juvie that she'll take me back." The public defender printed this out, showed it to the prosecutor. All charges were dropped, just based on one posting. So this is what the Topics board looks like in Ada, Ohio, where I work. Some things that a practicing attorney might find of interest. We have breaking and entering. Man leaving his baby to drink. That actually happened. The guy left his baby at home, went to the local bar, mentioned to people he had left his baby at home to drink. The police came, took the baby away. It is awesome. Deadbeat dads in Ada. Sorry, I moved past that one. And you'll notice that Dollar General down there, there are 48 comments about Dollar General. People have very strong feelings about their local retail outlet. Another thing that actually happened. Boyfriend was a sex offender. He was in jail, and he was on the phone with girlfriend. The guardian ad litem was involved in this because she was representing the children. And on a recorded phone call, boyfriend and girlfriend agreed that she was going to raise his bail money by turning tricks. There aren't a lot of places to prostitute yourself in Northwest Ohio, actually, because there's a lot of cornfields, and if you stand by a cornfield, you don't get a ton of attention. So she went on the guardian ad litem, realized that the place you get the most traffic for that kind of issue is actually the internet. Craigslist used to have an erotic services section, but that's disappeared now, and people are going to the casual encounters section instead, and replacing their S's with dollar signs to indicate that they will do that thing they're talking about for money. So she went on there and came across girlfriend offering her services with dollar signs instead of S's, with a photo that made it very clear who she was. And we couldn't include that photo because this is going to be on YouTube, and that would make this the wrong kind of video. So we're not going to show you that, but I do have a clip. I really do love that transition. From Craigslist, the Lima, Findlay, Ohio, casual encounter section on March 28th, 2013, just a snapshot in time that I had to put red bars over because people say that you can't actually bring into an academic presentation. But I will tell you that these slides have been uploaded, if you're really dying to know. These slides are uploaded on the Cali site, and you can just move those red bars later on. It's nothing too exciting, but it was enough that we didn't think it was appropriate to put it in the slides. Speaking of selling things on the internet, eBay is the new pawn shop. There were so many examples of this that we couldn't narrow it down to just one. If you Google looking for people finding their stolen things on eBay, it's happening constantly. So if you, for example, if your student is a prosecutor and they are looking to prosecute for stolen goods, it's worth checking eBay to see if someone is fencing their stolen goods on the internet. You'll probably need to do searches for something a little bit more specific than just stolen, because that doesn't tend to bring up a lot of results. And of course, Facebook. Facebook is my favorite because people do the weirdest stuff on Facebook. So, we have mother who is dating a convicted sex offender. She has baby, and baby is being represented by a guardian ad litem. Mother had multiple Facebook accounts. She created one for baby. Baby liked a bar, a porn site. Baby was like 7 months old. At her hearing, mother swore she was no longer dating a sex offender, and that was actually one of the big issues. The guardian ad litem had gone on Facebook the day before and had looked through mother's various profiles and had found a photo of mother and sex offender posted the day before the trial. It was a selfie of them in bed with the sheet pulled up, so it didn't violate any of Facebook's terms of services, but otherwise it totally would have. And it was captioned, after Lego. Which is just so gross. But that photo was admitted. It was pretty clear evidence. It was date stamped, time stamped. The guardian ad litem had the mother authenticated on the stand and admit reluctantly that that was her and the sex offender. And based on that, the judge was able to determine that she had perjured herself and was also bringing a sex offender into her home around her baby. So those are all sort of real life practical issues, none of which ever got to the stage in a trial where you would actually see case law coming out of it. But those are the 95% of what your students are going to be using social media for a legal investigation is issues like that, small issues that don't become the crux of an appeal case, but that make the difference between custody and not custody, or conviction and having the charges dismissed.
All right, so lessons from Steubenville, and this is kind of how we first got interested in this. Presumably, if you have been reading the news in the past several months, you have heard of the Steubenville case. We chose not to include any of the images or other social media evidence in this presentation. Some of them are fairly graphic. If you have not seen them, feel free to Google Steubenville social media.
They're not like entertaining graphic the way that the Craigslist thing is. They're genuinely disturbing.
But so we thought we'd pull some of the lessons that can be drawn from that case. So, number one, in case you are not already aware of this, evidence can be gathered from myriad social media sites. In particular, popular ones, Instagram, YouTube, Twitter, Facebook, all sites that were used in Steubenville. Don't just stick to one site. Check many of them. One of the key factors in Steubenville was that, this case had not garnered a lot of attention even from, sort of the local prosecutor until there was a vigilante blogger, Alexander Goddard, who heard about this, got interested, started digging into it, and started digging up all of these tweets and YouTube videos and Facebook photos and everything. So, bonus, the case got prosecuted. People are now paying more attention to this. The downside is that, there was a lot of backlash, a lot of local people were implicated. And innocent people may have been harmed by this. So it's definitely, when you're going over this with students, these are certainly issues they want to pay attention to. But one of the big challenges with social media evidence in particular is figuring out, is this true? Is this an accurate representation? Did this really happen? Is somebody making this up? Is this just a revenge thing? So really helping them focus on how what they're digging up can implicate people who may not necessarily be involved. in depth when we get into sort of strategies for bringing this into your classroom. You want to cast a wide net, not just in terms of the various sites, so checking Instagram, Facebook, YouTube, Vine, which is the one I always forget, but also the various people. The victim in the Steubenville case, none of these pictures, showed up on her Facebook feed, on her Twitter feed, so you couldn't have just checked there. And as we'll see, Alexander Goddard used sort of a multifaceted strategy, checking, the newspaper, the local football roster, some of the local forums like Topics, to pull together a list of who may have been involved. So not just, the defendants in the case, but also some of their friends, some of the bystanders, the other party attenders who were in fact filming this, even though they weren't necessarily the ones involved in the activity. So thinking broadly, who else may be involved? Where else can you find this information?
When you're teaching, it's important that you emphasize the practical and ethical considerations that your students are going to have to deal with in legal practice. Some important ones. That's a sock puppet and a catfish, if you were wondering. The first time Ellen saw this, she thought, why did Andrea put a muppet and a whale on there?
It's a cute muppet, but...
So, are your actions in pursuing the evidence morally and ethically defensible? Several bar associations have taken very firm positions that it is not okay for lawyers to sock puppet or create a false profile with the intention of friending an opposing party, which apparently happens. And I guess, from what I've read, that a lot of criminal defendants, before they put their feet down about this, a lot of criminal defendants were really prone to accepting a friend request from an underwear model who just happened to live in their city and wanted to know about their recent criminal activities. So bar associations have determined that this is an unacceptable way for a lawyer to approach a case. And that's something definitely worth emphasizing to students. Necessary steps to preserve and authenticate the evidence. This topic actually really scared me as a thing to talk about because preserving and authenticating the evidence seems like it would be so highly technical that it would take a lot of know-how. The more we delved into the literature on it, the less intimidating that concept is. The two main ways that you can preserve the evidence, you can either take an old-fashioned screenshot, which is what a lot of people choose to do. The plus side of that is that it's cheap and it's easy. The downside is that it lacks metadata that would otherwise be really valuable. You can also try to subpoena the social media provider to get the information directly from them. That includes all the necessary metadata and is a little bit easier in terms of bringing it into a courtroom to say this is authentic, the way that it was posted online, no changes have been made. The big issue with that is that most social media providers are really bulldogish about their users' privacy, which is great when you're a user. It's a little bit of a problem when you're an attorney because Facebook, for example, has clearly stated they won't release that kind of information without a court order. So if you as an attorney want to get that, you're actually going to have to put in the time and the expense of going in front of a judge and explaining why you need it and subpoenaing it. It's not a quick or easy process. So it's not necessarily the kind of thing that a public defender or guardian ad litem is going to be able to do in their day-to-day work. And finally, can you get the evidence admitted in court? So initially, I thought going into this that it must be really hard to get these things admitted because everybody knows someone who claims that their Facebook has been hacked. I didn't post that status at 2 in the morning where everything was misspelled and I mentioned that I was at my 7th bar. I must have been hacked. So you would think it would be tougher to bring it in front of a judge, but apparently in actual legal practice, increasingly judges are, as long as you can authenticate this is the person, this photograph is of the person it is supposed to be of. This is an actual Facebook account that exists. Once you can do that, judges are allowing attorneys to bring in this kind of evidence and trusting the juries to understand that Facebook, MySpace, those sorts of sites are inherently a little bit less trustworthy than some forms of evidence. And they're letting the juries themselves weigh the value versus the risks of it. So getting the evidence in the court, you have to cross the usual evidentiary hurdles. But in terms of special things that students need to know, they can actually usually approach this sort of thing more or less the way they would a document or a photograph. They authenticate it in basically the standard way.
All right, so let's making your research plan. Equally important, keeping your research log and organizing it in some manner so that you can find it again. And bonus, if your students focus on the things they need for a plan and a research log, it will provide them with the necessary information to help them authenticate all of these documents in court. So, everyone has their own preferred way to research. I like to use the Rombauer framework. If you're familiar with the Rombauer framework, step 1 is your preliminary analysis. Step 2, research your statutes. 3, your mandatory case law. 4, your persuasive case law. 5, refine, double check, and update. Clearly you can sort of collapse that, take out the middle steps for this, but focus on your preliminary analysis. Your students might think, oh, it's just Facebook. I can just go on there and find, whatever it is. I use Facebook every day. Preliminary analysis is not a waste of time, as you will see. Legal research can always be a rabbit hole, right? You think you know where you're going, and you're like, oh, I totally found this case, and then 20 minutes later, you're somewhere else, and you're not really sure. Have you checked ALR just in case? Have you checked all of the cases that you need to? Taking a moment to write down a search strategy will help make sure that you don't miss anything. It is even easier, I have found, to get completely sidetracked when you're doing research online because people have fun pictures and you want to click through them and other exciting things. And then finally, refine, double check, and update. It's particularly an important step because one, in case you hadn't noticed, the internet is changing like all the time. People delete things, they keep adding things to Facebook, which does not make it easy. And then as we discussed a little bit earlier, you really want to make sure that you have done the best job you can to make sure that this is actually someone's social media profile and that it was posted by them or the comments were made by them. So spending a few moments with your students to talk about how can you actually authenticate this? How can you tell if this is someone's Facebook, MySpace, Twitter, Vine, YouTube, Instagram profile? All right. So focusing on the preliminary analysis, which is that first step of the Rombauer framework. You want to think about the facts, your search terms, your issue and jurisdiction, which is, again, ordinarily 2 steps in the Rombauer framework, but I have combined it here. Your search strategy and your knowledge assessment, and then, surprisingly, yes, still your secondary sources. We have put up a sample research plan on our program page on Cali, so definitely make sure you download that. It presents basically the same information, but in a slightly more traditional format. All right, so your facts. Very, very few people have unique names. If you are so unlucky as to get someone named, say, like John Smith, this is the first thing that will come up if you Google John Smith. I'm guessing this is not the one you're looking for. So when you're thinking about your research plan and listing the facts, what do you know about this person in addition to their name? What can you come up with? Is it the location where you are now? Is it their hometown? Is it their alma mater? Is it their employer? You must know something else about this person that will help you narrow it down from the John Smith that was in Pocahontas to, say, the John Smith who lives in, like, Ada, Ohio. I'm guessing they're separate people. Your issue and jurisdiction. Again, taking a minute to think about what are you looking for. Are you just looking for photographic evidence that mother is still hanging out with a convicted sex offender? Are you looking for writings discussing potential future and definitely current drug use for custody dispute? Are you looking for video evidence so that you can tell, what happened? You might be looking for anything you can find, also a valid strategy. And then thinking about where you're going to find these. Is this person going to be on Twitter? Topics definitely exists in Boston. It's kind of interesting. It's definitely not as interesting as the one in Ada, Ohio. So think about what is popular in your area. And finally, when. Are you just looking to see what the person is doing now, the day before trial? Do you need something from the archives? One really interesting feature of Google News, I know it shows the current news. If you go to like search tools, you can pull up the archives, and it will take you all the way back to 1900. It's just way to see if, you know, the person you're researching has ever shown up in like the arrest notes from the local paper. So again, thinking about, you know, are you looking for current information, or are you going to have to dig a little bit more to try and find this? All right, search strategies, search terms. It's always a good idea to brainstorm your list of search terms when you're doing traditional research, right? Yes, hopefully. Just as important when you're researching people. I do this exercise in class with my students. I usually use myself, partly because I know it's out there. I have vetted my own social media profile, so feel free to Google me. You'll see exactly what you're going to see here. The other thing I discovered when I was putting this together, Google is really smart, but it's not that smart, and so it definitely depends on how people spell their names. So, again, I am Ellen Richardson. If you Google Ellen Richardson, yeah, definitely not me. Sometimes I throw in my middle initial because when I became a librarian and I Googled myself originally, I discovered that the Ellen Richardson that used to come to the top of the Google search results is a convict in California. Her slogan for a while was an incarcerated soccer mom. And so I was like, all right, well, how am I going to differentiate myself? I'm going to throw the middle initial in there because there are fewer Ellen M. Richardsons than there are Ellen Richardsons. That is, in fact, me. So once you add in my middle initial, even though Ellen Richardson is still my name, that's how I've been spelling it for the most part online. So now you're actually getting information that's me. But sometimes I use my full middle name. Why? I don't know. I was just having a different day when I set up my LinkedIn profile. Again, me. The interesting thing is that if you Google Ellen M. Richardson, you're not going to get this photo. If you Google Ellen Minot Richardson, usually this one doesn't pop up either. So think about your search terms. So like, what is the person's name? And then think about synonyms. How many other ways can this person spell their name? Do they go by James? Do they go by Jimmy? Do they use their full middle name? Do they use their middle initial? Sometimes my dad will be listed online as just Tom Richardson. Sometimes he'll do, you know, Tom Richardson III. So just thinking about different ways, and then also running all of those searches, because clearly if you had just done Ellen M. Richardson, you're only going to get half of what's out there. But if you had just done Ellen Minot Richardson, you're still only getting half of what's out there. It's accurate, but it's only half of the story. All right. You also want to think about related terms. So if anyone has ever researched family law, you'll know that depending on the court, children may be referred to as children, they might be referred to as infant, they might be referred to as minor child, they might be referred to as boy child, as girl child, all the same, but pretty much related terms. With the exception of those two photos that you just saw, I have my social media profile fairly well locked down, so if you're looking for me on Facebook, you probably won't find it. Similarly, if you're looking for photos of Randy Zuckerberg that are not in the news, you would have less luck finding them. Except for this one. If you saw the news back in December, this Zuckerberg family photo of them all poking each other appeared on social media. And Randy Zuckerberg was not very happy about her private photo having been shared everywhere and wanted to know where everyone had got it. It turns out someone else in the photo was tagged and allowed her friends to be able to see this. So, a friend of the person in the photo found this photo of Randy Zuckerberg and posted it everywhere. So even though Randy had her profile locked down, her friends were tagged, and their friends were able to see it and take the photo. So if you can't find Facebook photos of the person you're looking for, think about who they're friends with, because chances are they may not have their social media profile locked down and you'd be able to see it. We saw this as well in Lalonde v. Lalonde. Even though the mother had not posted the pictures, her friend had, and they were clearly photos of her. So again, for your own sakes, be careful who you're friends with, what they're tagging you in, and definitely check all of your clients' friends, just in case. All right, the final step in that preliminary analysis is to develop your research strategy and do sort of a knowledge assessment. And this is really going to depend on resources like the high school football website. It can give you a team roster. And then she took those to the local forums to see who's friends with who, who's doing what. And then started looking through their social media profiles to find what was going on. And that's how she found a lot of the information from Michael Nodianos, who had the YouTube video particularly illuminating Twitter feed and several other items. So just expanding your strategy, thinking about, in addition to Facebook or Twitter, where can you find this information? Part of that knowledge assessment is, if you're sitting there going, I have no idea where I'm going to start, I don't know where I'm going to find this information, you can still consult your secondary sources. If you have a photo, Google reverse image search and TinEye are two really interesting features. They're not perfect, but you can either upload a photo or insert the URL of a photo. If you're in Google image search, you click on the little camera, you can insert the URL, and Google image search will find you two things. It will give you its best guess as to where the photo originally came from, and then it will also find you anything that looks like that photo. So you can clearly see that I keep using this photo everywhere, and also that I invent double A, double L. This is one of the things that came up in that Monte Teo Lenny Keikoa scandal. The image in the profile for Lenny Keikoa had been taken from someone else's social media profile. The challenge with using these is that if the metadata on the photo has been changed, Google has a lot more trouble finding where it originally came from. It will do its best to find you visually similar images, which may or may not be the same person. When I do it on myself, it's usually pretty much just people who are blonde. None of them are actually me. But they are improving their algorithm all the time, and so eventually, whether this is good or scary, it will probably be able to do a much better job of finding photos and using facial recognition to find photos of the people you are actually looking for, which will be another tool to track down various social media sites. For the most part, I think we're all familiar, certainly many of your students are familiar with the myriad of social media sites that are out there. One really excellent resource is the Carol Levitt book, Find Information Like a Pro. She has many strategies based on, what are you looking for, where can you find it. It's particularly good if you need to also track down some public records, birth certificates, divorce certificates, things like that. All right, so in addition to your research plan, you want to encourage your students to keep a research log. As Andrea mentioned earlier, print or save everything you find. It will disappear. I used to work in the Guardian ad litem's office, and so one of my jobs was to go through the MySpace pages of our clients' parents to see what they were doing, what they were posting, and we would print everything to PDF because that will give you the URL at the bottom and then the date that you found it so that you can demonstrate, yes, on May 12th, this is what the photo showed, even though our client said, or our client's parents said on May 5th, this is what was happening. However you decide to save it, make sure the item has the date and the web address. Taking notes on where and how you found it, which will help you with a couple of things. One, the court will probably ask you where and how did you find this, and then you can say this is how. And second of all, it will help you narrow down which parts of your strategy were successful. Again, if you were Googling me and your only search term was Ellen Richardson, probably not such a successful search. You would find many things about a convict in California, a dentist, but not a whole lot about a law librarian. So focusing on which of your search terms actually worked, what is this person using as their name? That will also help you later when you need to go back and update your search to see if any new information has been posted. You'll be able to remember, hey, this is what worked last time. It'll make your subsequent searches easier. Finally, again, keep it clean. Courts have frowned on sock puppeting and catfishing. Generally, sticking to publicly available information. If you can find it without friending someone, or you can find it through Google, or they've just let their entire MySpace page hang out there for the world to see, generally good to go. Again, that will also help you inform future portions of your research strategy. Courts are increasingly open to interrogatories and discovery requests for this information, properly tailored. So doing the publicly available information first should give you a better idea of what is out there so that you can craft a properly, narrowly tailored interrogatory or discovery request to get at the information that you can't find through Google and other options. All right, refine, double check, and update is the final step in our Rombauer framework. Again, refining you'll be doing consistently throughout, throwing out Ellen Richardson as a search term, but keeping Ellen M. Richardson or Ellen Minor Richardson, or hopefully both. Updating goes without saying, people are posting things several times a minute. I think, how many Facebook posts have we had this morning already? I think we've had 2 or 3 this morning, all with the selfies and people wishing us good luck during our presentation. So keep checking, this stuff is out there. Double checking. So this can be the tricky part. We've discussed how one of the big hurdles is making sure that this information is from the person that you say it's from. On April 15th, Shahar Sarnaev put down a backpack on the Boston Marathon. Oh my God, people found his Twitter profile. Look, it's right there. And would you look at what he's tweeting? Oh God, it was just awful. It's truly terrible. But wait, there's another one. Does he have 2 Twitter profiles? Is this one his Twitter profile? Is this one his Twitter profile? How can you tell? It's obviously a little more difficult with social media to tell if this is actually someone's, real information. So it involves still being critical consumers of legal information and a little bit of logic. When you're looking at social media, a couple things to think about. This one, by the way, is a fake profile. How can you tell? This photo is not obviously ripped from the headlines. This is like a real photo, not something that anyone could have gotten their hands on. Typically, people will have sort of the same number of friends or the same number, especially on Twitter. They'll be following or followed by kind of like equal numbers of people if you are like a regular average person and not, Britney Spears. On the fake one, he's following one person and he has like several thousand people following him. Presumably, like your average college kid from Boston does not have several thousand followers while only following one person. The real one, unfortunately, now has over 100,000 followers. I can pretty much guarantee you that like on April 15th, he had way less than 100,000. But he's also following more than just one person. Finally, most people have fairly deep social media profiles at this point. Scarily enough, Facebook has been around since my senior year of college, so I think I have like 8 years of Facebook history, which is actually kind of disturbing to think about. But the point is that normal people will have more than just one day of social media postings. It will probably be going back to before the event in question. Very rarely do people say, I did something totally crazy. I'm going to open up a social media profile and tell everybody about it. Usually they already have one and they already have an audience and they're like, now I'm going to tell people about the crazy thing I did. So just thinking about what would the average person's profile look like. They're going to have friends. They're going to have probably an interesting picture that you could not find elsewhere, but you never know. And they will have sort of a deeper history. His postings go back, at least on the screenshot, like mid-April, as opposed to having 15 or 20 from April 19th when he was madly being chased by the Boston police. All right, so additional thoughts on teaching.
Just a few extra things. So the stories that I was telling earlier are all courtesy of one of our alums who came in and spoke to a legal research class and told the stories herself. And that's something that you can absolutely do in the classroom. If you have alums or local attorneys who are doing this kind of work at all, usually they're more than happy to come in and talk about their experiences because these are the kinds of funny stories that not everybody cares about or wants to hear from them, but they love to share. So having them come in can really drive home to students the importance of this kind of research and the value it's going to have in their actual work. Social media is constantly evolving. Don't get hung up on one search strategy. obviously, the internet in general is always evolving. Our speaker this morning was talking about how strategies deprecate, and I think that that's really appropriate here. Because if, for example, you use your lesson plans from 3 years ago and you go into class talking as though MySpace is the hip new site that all the kids are on, you're going to sound like somebody's nana. And even if you are their nana, that's fine. But you don't want to sound outdated and out of touch. So instead of focusing on the specific sites that people will use, teach them how to do it, and trust that for the most part your students are probably very social media savvy and will know themselves what kinds of sites they need to be checking out. Finally, do a live example. But Ellen uses herself.
Because I know there are like no surprises out there.
We make a point of vetting ahead of time, checking out the students' social media footprint to make sure that nothing awful is up there, because it would be super awkward to out someone as an exotic dancer or an escort in front of a classroom with their peers, and you want to avoid doing that. So do your homework ahead of time. Don't ask for volunteers or anything like that. Figure out who you think is a safe bet, and do some research before you get in the classroom. And that is pretty much what we've got. We would love to open the floor up if anybody has questions or comments.
Or additional strategies they use for teaching us to share.
Yes.
Have any state bars issued opinions on this kind of research, or are they still trying to play catch up?
A couple of state bars have definitely come out and said that sock puppeting is unacceptable. There's been some discussion of whether you can friend judges, other attorneys. They've pretty clearly laid out that if opposing counsel or if an opposing party is represented, you can't friend them because that would be making contact in an admissible way. But if they're not represented, it's a little bit more up in the air. Those are the big issues they've touched on. I think that other than that, research is still a little bit of gray area as far as state bar associations are concerned.
Yeah. A lot of states are still figuring that out. Obviously, New York has clearly, the New York Bar Association has clearly said that if it is publicly available, if you can find it through Google or without adding this friend on Facebook, it is completely fair.
Well, and that begs the question. I mean, when are we going to teach people not to friend not everyone's your friend, you know? And it's important to understand that you're going to use online profiles, how to. If you put it on the internet, it's just not safe. I don't care, you know. I mean, it can get found out at some point, you know. But so how do you educate people just to stop putting their entire lives on the internet? You know, I mean,
We thought about that as a topic, like how do you approach this with law students, but then we realized that's actually something that has gotten a fair amount of traffic, that people do emphasize to law students they need to clean up their social media profiles, and that this particular approach to teaching the subject is more of an opportunistic, hey, not everybody knows this, so I will take advantage of their weakness and exploit it in my court case, which...
But don't you think the opposing counsel, though, would talk with their clients and say, you need to take all this stuff down?
That raises actually a great point that I meant to bring up earlier, which is that some courts have determined that telling your client to clean up their Facebook profile is spoliation of evidence. So as an ethical issue, you're not supposed to tell your client, hey, that post that you just made about murdering someone, you should take that down really fast. That is actually unacceptable. So they're not supposed to post it in the first place. And certainly we should be emphasizing to law students to be smart about their own social media use. But from a really practical, hands-on perspective, they kind of win if other people aren't being smart about it because they can use that in their research, and they should. I guess that's sort of our big idea, that this is a thing that's really happening. No matter how much you tell people to be smart about their social media use, they're just not always. And in order to be really diligent in their representation, students need to know how to do that, even if in a perfect world they wouldn't be able to.
One reason that my own profile is so clean is because my 1L year of law school, our legal writing professor, brought us in on a Friday morning, and then announced that he'd been going through all of our social media and Facebook profiles. He actually has a group called, I think it's called like my legal writing instructor, like checked out my Facebook profile. He went through on like an individual basis and was like, hey, you get a little drunk last weekend, you might want to take those pictures down. Apply for the bar. My entire class of like 30 people left just panicked and started deleting things immediately. There were 30 of us with like the squeakiest Facebook profiles you will ever see because we deleted everything and would not let anyone post anything for the next 3 years of law school. So totally scary, slightly invasive experience, but definitely probably very helpful when compared to some of our other classmates and some of the things that we saw them posting. We're like, oh, wouldn't do that if I were you. So that's one strategy for you.
Michelle?
I was just going to ask if you felt that there was maybe a secondary benefit by teaching this to the students about how to use it in their practice, that they actually, that they actually see the examples, and it just kind of does reinforce what they're maybe hearing from admissions or so-and-so career services about that it actually gives them examples of, oh, if I can find this about John Doe, people probably can see that stuff about myself.
You would hope. But I'm not actually sure if that happens. Yes?
It occurred to me that knowledge management tools like Zotero, which you can go to and grab content from a page, might be really useful in that it actually grabs the data and, I believe, the net metadata and provides some data access information, assuming it's good enough to be admissible, and also as long as you don't refresh it. And also provides very good organization. Might be a tool worth teaching.
Evernote's web clipper might work as well. Things to experiment with.
The questions, the two questions. If you're in a jurisdiction where the bar association says it's clearly it's unethical to defend say the defendant, how do you suppress that evidence from admitting to the court?
I'm afraid I don't understand.
Like you've got the evidence,
Yes.
unethical in the jurisdiction,
Yes.
and your attorney, assuming that the attorney for some or whatever reasons, get the evidence into the court through a whatever. If you're the opposing counsel, how do you suppress it? How do you get it not to the evidence into? Because ethical rules, the rules of evidence are different.
Having only practiced very briefly, I'm not 100% confident about actual courtroom strategies in this kind of issue, but I think it varies a lot jurisdiction by jurisdiction.
Right. What I'm telling you is the jurisdiction where it says it's clear. And so basically the second scenario is that in the situation, so the first one is the jurisdiction says that you can't. There's a opinion page, but there's only right now, 33 jurisdictions say you can. But there's other situations where the jurisdiction is not clear. There's no opinion about it.
Well, if they have clearly said it, if I were the attorney, I would probably go to opposing counsel and politely let them know that I was going to be filing an ethical complaint against them as soon as they brought that evidence into the courtroom, which in most cases I think would be enough if the Bar Association had already. Otherwise, I honestly don't know what the trial strategy to keep that out would be. It might not be kept out if nobody has said that it's not okay.
I mean, it's an interesting question, and that's one that was not covered in any of the readings. So if anyone does have an answer to that, definitely let us know. We'd be happy to add it.
The literature on this is still so new that in a lot of cases the authors just openly say, we don't know. Give it a try. Let us know how it goes. It's kind of a neat area to be looking into right now because it's really almost a laboratory setting. People are just throwing everything at the wall to see what sticks. So if you would like to go get into some serious trouble, post about it on Facebook, find an attorney, litigate it, and let us know. Seriously, you would probably be the test case because I don't know that it is a thing yet. But you probably have better things to do then. Yes?
But that raises some interesting evidence issues about authentication. I mean, obviously, websites are highly subject to manipulation and fraud, and maybe you run into some evidentiary rules. I mean, have there been findings? I mean, are judges just letting these in without questioning at all about how the evidence was gathered or whether or not the website might have been tainted somehow?
No, and that's been sort of the major issue in bringing this evidence into court. You'll notice in the bibliography, a lot of the articles are from state bar magazines because it's primarily, again, being dealt with at a statewide level at this point, and so it's not that we're suggesting Essentially, to this point, most states have been following, the rules of evidence for authentication of communications. They're being generally entered into evidence less for sort of the truth of what's going on, saying, oh, you wrote on your MySpace page, hey, I killed Beezy last night, therefore it must be true because you wrote it, and sort of more to impeach the witnesses. Generally, in, which case was it? I think it was in Griffin versus Maryland. The witness said, this is a photo of the person in question. This is the nickname that they typically go by. And, the court sort of said, okay, well, you authenticated it in terms of this is, most likely belonging to that person. And so again, using it more for impeachment evidence and less in terms of the truth of the matter asserted. Yes, Steve?
Yeah, I think the answer to that question is you have to look at two things independently. One is admissibility, right? And then the second is going to be the weight that the jury is going to give the evidence. And I think Andrea said this, right? I mean, if you meet a certain amount of benchmarks, this is the page that it's from, this is the date and time are accurate, that sort of thing, then you can argue to the jury one way or the other and simply say, you shouldn't give this evidence any weight, right? And just separate weight from admissibility in that regard. And then the second point, as to the suppression of the evidence, I don't think it has anything to do with ethical considerations within the jurisdiction. It has to do with whether the lawyer is obtaining the evidence via deception, right? And that too will go to its weight, its admissibility. It'll go to whether it was obtained lawfully, that sort of thing.
So I'm actually a law firm librarian, and my field is I'm specifically an IP librarian. So I've been doing that for about 9 years, and in trademark law. And so a lot of that is tracking the history of these things appearing. So I use social media like mad for most of my evidence gathering. And we actually had a case where I wrote the affidavit for the evidence that a company had been using different social media sites and job posting sites, infringing on our client's trademark. After they got sued, we had not captured the site at the time that we noticed the infringement. That was a mistake. When they got sued, they immediately took down all those posts and they claimed they never put them up. Said that to the court. I was able to go into archive versions and site scraper sites that actually replicated posts. So site scrapers can be actually incredibly powerful for capturing data that's already gone from the original site. And the embedded links in it showed where it had originally been. And those posts were all dated, so they were actually still within the websites. They were just kind of hidden. They weren't pulling it through the database. And it was my job actually to educate the judge on how these sites worked. And it was quite a lengthy affidavit about how this worked, what they had done to make these links disappear, and that they had intentionally basically defrauded the court. And the judge basically blasted the other side for defrauding them and saying, are you really telling us that this is what you didn't do? So I find a lot of it's done through, and I've done a number of affidavits like that, so a lot of that I know the attorneys sometimes do too, and I'll walk them through it on how to explain. They always have to educate a lot of these judges or the juries about how these things are done, so that's a big part of it. And the capturing is huge, but the date URL, and the problem is a lot of attorneys don't realize that the PDF settings may not show that, and their print from the browser may not show that. They have to make sure those settings are present, or it won't be capturing that. Becomes a major problem down the road, like we discovered when it hadn't been captured in time. So I just wanted to comment on that, and it's huge. And the other thing is too, because of all the problems with the attorneys doing stupid things online, more and more law firms are blocking them from all these sites. In my old firm, no attorney could get onto any social media site like Facebook or MySpace. I had to do everything like that. And at our firm now, while a lot of it's not blocked, I'm in a new firm now, the attorneys really don't do this research. It's all through the librarians. So if you're looking for people to maybe comment on legal research class, a lot of the local librarians at the bigger firms, we're mostly the social media investigators. And the attorneys are still somewhat confused on what's out there. And we have to kind of keep them from going off the reservation. The younger ones who think they can do everything and find everything, and they can get a little dangerous in what they think they can and what they shouldn't do. So just a comment on that about where that kind of research is shifting more and more in the long term.
Other thoughts, anybody? Well, thank you guys so much for coming. You were a really unscary audience, so have a nice day.
How are you doing?
I was considering it, I was like, that would be too meta, like meta. Oh, well done, that was wonderful.
Sorry we were late. We tried to go around and see if we could get
First.
Got one for us, stick figure?
No.
But I never met him personally. So every time we start a conversation and Carla says, "Hey Ben," I just assume it's her. And don't remember until halfway through the conversation, there's actually a different
Here,
answer. So
Kim.
frequently, I'll
Take our picture with Brian.
probably
You really want to be here today.
because I always talk to him, but like I actually know who he is. And then
Kelly, Wanda, she's
I was like, oh, so like, it's such a great Callie. And then he's like, well, who? I was like, well, you meet Carla, and I'm like, I just assumed you knew Carla. He's like, oh, no, I'm not.
That is pretty good.
And then, well, he goes,
The classic relocation.
It's
just like it.
Oh, well, yes.
Turns out, and then you are a model for all that.
That's, yes, that's.
That's the moral.
You might have to.
Well, I'm kind of Ellen. Yeah, I like Ellen. I might have download. But.
Yeah, no, I figured out what it was with the stickers. I'm all about that train, if it was listening to that. You know, my procrastinating way of getting through my career. Well, it was Lori's idea. She did all the